How's everybody doing? Okay, come on, man. It's 9 and we are going to rock. Okay, exactly. Rock the house. We are going to get this done. 9 a.m. bright and early at a HackerCon. Who the hell made that fucking schedule? Needs to be shot. All right. Administrative remarks. There's other people here at the hotel, and 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 from my perspective, I really appreciate it when I don't have to be downstairs talking with security at 3 o'clock in the morning. So be respectful of your fellow human beings on this little rock that's spinning around the fucking sun. All right. Do that for me, and I'll really appreciate it. You don't have to respect their organization. You don't have to respect for what they stand for. I mean, last year, what we had to deal with was either one, people getting slowly converted to an evangelical nature of some sort, simply by osmosis, maybe. This year, we have people that are highly skilled at bringing you to the way, the truth, and the light, which is their thing. And it was cool last year. You could be on an elevator with 3 nuns wearing your S&M gear, and just that happening was kind of cool. But there really wasn't any issues with that. This year, somebody's targeting folks in black shirts apparently. So you have been so warned, and just be cool and be yourselves, and because we don't cause problems, right? We don't cause problems. So that said, and I don't have to say that kind of shit again. The air wall will go back up after keynote, so just steer clear of the wall, mind the gap. And tonight's party, doors open up at 8. I highly recommend lining up around 7:30 or so at the club if you really want to do that, because the bar opens up at 8, and who knows who else will be there and consuming the free drinks. Only if you give them your little blue wristband, dude. Great question. There's the place actually is not too far from a metro stop. It's not right on a metro stop. Sorry about that, guys. I made some calls to the NRO and got the weather changed for you, okay? But I just can't seem to get fucking DC to build a metro right next to the club we want to be at. They started putting the laser beams down. Not a problem, sir. Okay, there's cabs. And last year was interesting because I actually got into a cab and said, here's the address I want to go to. And the cabbie was like, I don't know where that is. I said, we're getting the fuck out of this cab. He said, you can't do that. I was like, really? So I told the 3 other people in the back seat and myself to get the hell out of the cab, and we went to the next one. But make sure that you have the address, and we actually provided some instructions this year on how to get to the place driving-wise, so you can actually give that to your cabbie if he is of the variety of people in DC that don't know DC. And then there's Metro as well. And maybe some people will split a cab with you. It doesn't end up being expensive when you just split a cab, and it's not that far. The club, like I said, opens up at 8. I'd say, if you want to get free drinks, and last year people griped at me because they didn't get a free drink. The money runs out because guess what? You fuckers drink, okay? And it's not like we're putting, just like $10 on a bar tab and waiting for the first guy to get a free drink, and then it's all over. You have to pay. No, there's a good bit of money, and it is all from our sponsors, and it provides you with a good warm-up session maybe for the rest of the evening. 8 o'clock to 10 o'clock, place is completely ours. 10 o'clock, you get to mingle with other giblets of humanity, and they will be filtering in, and Keith's music, which starts at 10, will actually be pumped into multiple locations. So don't feel you're missing out if for some reason there's the number in terms of what the fire marshal will allow for the room that we are commandeering completely to ourselves starts to overflow. Keith's music ends up actually going into multiple locations. So you can move freely back and forth between the 2 rooms and assist your friends who want to go in and out of those 2 different rooms, okay? So don't be elitist and just stay in one place. I won't, so you shouldn't either. And that's any other questions about the club? Dress code. All right, they call it sophisticated and chic or something along those lines. A t-shirt won't probably get you in, okay? A t-shirt probably won't get you in, but probably not a black one. Hats are right out. It's probably the first time you guys will see me without this bad boy. And it's my little security blanket, and so I'll be asking for self-affirmation from you while I'm there at the club. Do I look okay? So I don't wear my hat when I'm there, which is not very often. But I mean, that's one of their things. A button-down shirt, jeans, and some sort of shoes that are not Nike variety will get you in the door. But I don't control the dress code. The club controls the dress code. If they reject you because you're not hot enough, it's not about looking hot. It's simply about meeting at least a minimum standard of what they expect for their club. So let me know if they well, don't call me, but let me know the next day when you didn't get into the club, and and then I'll see what I can do. Any other questions about logistics? What's going on today? And it's difficult to even see. If there's hands, yell, because I'm blind at this point. All right. Pablos is actually going to come up now and give an intro for Jennifer. I will simply say a few different words. One, I met Jennifer a couple years back and hung out with her, and she is one of the coolest people on the planet, and she also likes comic books, and so we immediately latched on, and it's been a fun legal and comic book ride since, and and so I'm really glad that she's here talking. I really wanted her to be here last year, but she had schedule things, and so she is here this year, and Pablos will give a better introduction than I could. Thanks.
I was going to give a better introduction, which I'll mostly remember, I think, as soon as I wake up at around noon. We have known Jennifer for years, and one of the things that one of the reasons I think that we wanted her here this year is because over the years, a lot of us have, as Dan said yesterday in his talk, we kind of became security experts through some bizarre course of life, and I think a lot of us have kind of gotten a little distracted with just doing security crap, and I think that that's kind of a sad thing for hackers, because hackers are kind of a brilliant folk who think differently, and that's why I'm here. That's why I like hanging out with hackers, and I could be hanging out with supermodels backstage. So the thing about it is, what we try to do here is sort of let people know that this is more, like a way of thinking, and we want to be interested in how the process works and how hacking is sort of a different way of looking at things and tearing things apart and building up different things. It doesn't just have to be firewalls. So Jennifer has been gracious enough for most of her professional career to hang out with computer hackers and has done some amazing things. She's given us all kind of this, ethereal, probably totally fake confidence in what we're doing because, we have at least one lawyer we can call when things go south. And it's been really, it's very encouraging, and it's been very helpful both practically for some of us but also just as sort of encouragement. And so what she's done over the years too, especially the last few years, has really started taking that to another level, starting to show how computer hackers are not only just okay, but also actually a pivotal part of society and the future, and how we get things done. And I'm really sorry that I can't give a better introduction. Jennifer Granick. Have fun.
So first I want to thank you all for having me here at Shmoocon, and then second I want to thank you all for the even greater feat of showing up at 9 in the morning to hear me talk. I really appreciate that, and I'm happy to see so many people. For those of you who don't know me, I got my start in this business as a criminal defense attorney. And I decided that I was going to start to represent people charged with computer crimes. And this was something that I needed to do because my boss was like, you need to get into white-collar crime. That's where all the money's at. So I said, yeah, white-collar crime. Okay, well, I didn't go to law school so that I could help people with their bankruptcy fraud case or something like that. I need something that's white-collar, but that's still going to be interesting to me. And I had my sort of geeky interest in computers, nothing like I'm sure most of you guys, but and I thought, well, this is a good way to combine my interest in the law with something else. So I decided I'm going to learn about computer crime and what the laws are and all of that stuff. And it was great, and it's been totally great ever since. It's a wonderful, I've met wonderful people. I've learned a ton of stuff, and I made no money at it. That was really the bad part. And then, of course, I had to go into academia where they pay me to make no money and to talk about these things. So now I work at Stanford Law School, and I run a clinic there, which is a public interest internet law clinic. And one of the things that enables me to do is to work on cases without having to worry about whether the clients have any money, which is just such a liberating, wonderful thing, and actually allows me to serve this community a lot more completely than I maybe was able to do earlier. So it's been really great. And, I thank Stanford for the opportunity to be paid for something that's completely unfinancially productive otherwise. So, yes, thank you, Stanford. So what I want to talk about today is the NSA wiretaps. And as most of you in this room probably know, in the middle of December, the New York Times reported that the president had authorized the National Security Agency to wiretap American citizens without a warrant. And federal statutes prohibit, as a general rule, eavesdropping on American citizens without some kind of warrant. The Constitution says, you need a warrant. Statutes say you need a warrant. And nonetheless, President Bush defended this policy on several grounds. And that launched this whole legal debate in the newspapers, in the press, in the blogosphere, among, around the water cooler, about whether or not this policy was legal or illegal. And my position on this, just so you're clear about what my bias is that it's absolutely crystal clear. The law is crystal clear, and the president broke the law. The law requires a warrant, and there was no warrant. And I think, just as a sort of a slightly broader view, that the problem with this is it's, once you start disobeying the law, it's the first step from being a society that's free but doesn't always necessarily live up to its principles to a society that's totally lost track of what those principles are. A difference between a free society and a society where at least some people are incarcerated without lawyers or charges or any end in sight. A society that is not free. But what I want to do this morning is not so much evangelize to you guys on that point, although I will be discussing that, but to take the wiretap issue as a kind of example and look into it about some broader questions about freedom and safety and security and how those concepts fit together in our legal regime. To look at the role that citizens play and to look at the principles by which we structure our laws and our Constitution. And I think that this is going to be particularly interesting to this crowd because as maybe it doesn't come as a surprise, but maybe as a little bit of a surprise, it turns out that the principles by which we construct a free society are actually kind of similar to the principles by which you construct a secure design, a secure system, secure computers. And so my thesis is that hackers have a special role to play in this historical moment in dealing with the question of how we as American citizens can be both safe and free. And that hackers have a really important role to play because hackers, first of all, well, hackers are adept at the two things that we really need at this point in time. One is asking the difficult and dangerous questions, and two is understanding how to construct secure systems and the principles by which that happens. And by secure, I mean a system that's not only secure from, or that's secure from both crime, terrorism, and also from fascism and unwarranted government intrusion. Okay. So what are the design principles that I'm going to look at? Well, I was reading, if you can believe this, a book called Computer Security, Art and Design by a professor at UC Davis named Matt Bishop, so I just want to give him credit. And he talks about a couple of principles of secure computer design. And these are, and I'm just going to read through these, but we'll get into these, I'm sure you guys know, but a little bit more in depth later. Least privilege, fail-safe defaults, economy of mechanism, complete mediation, open design, separation of privilege, least common mechanism, and psychological acceptability. And then I'm going to be talking about some legal principles, and hopefully you guys are a little bit familiar with these as well. And these legal principles are the principle of separation of powers, checks and balances, the principle of due process, of burden of proof, transparency and oversight, limited discretion, and finally the rule of law, and the importance of the rule of law in our system. Okay, so let's take a slightly closer look at the NSA wiretaps. Question is, were these illegal? As a general rule, you can't wiretap American citizens without a warrant. There are basically two statutory schemes for authorizing warrants. One is for taps that are conducted primarily as a part of a criminal investigation. These are your wiretap warrants authorized under we call them Title III warrants, and you need to show probable cause of a crime in order to get one of these warrants, in addition to many other things. And then there's another regime for foreign intelligence information targeted towards sort of national security. And that regime requires you to show that the person generally requires you to show that the person who's going to be tapped is an agent of a foreign power, either a foreign power or an agent of a foreign power. So when you think about these privacy policies that we have enshrined in statute, the question is you sort of look at, or sort of a framework for thinking about it is, what information are we protecting? Who are we protecting it from? Under what circumstances can the information be revealed? What safeguards are in place in order to make sure that it happens the way that it's supposed to happen? And what's the penalty if somebody does the wrong thing? And penalty is really important. When you're a criminal defense attorney, penalty is kind of everything. But it's sort of true. It's like you can have a right, but what we say is a right without a remedy. Is that really a right? Will people actually respect it? So you look to, is there some kind of way, some kind of backup to enforce the law? Okay, so both statutes set up similar kinds of schemes, both the wiretap Title III statute and the FISA statute. So FISA is the Foreign Intelligence Surveillance Act. It was passed in 1978, and it is the law that authorizes the wiretaps on American citizens who are agents of foreign powers. So the statutes they protect a certain type of information. They protect the content of your communications, what substantively it is that people are saying to one another. They draw distinctions between protecting citizens and American persons, non-citizens, and foreign powers. It protects information from being wiretapped or intercepted from everybody, but particularly from the government. It has special standards that it sets forth, which the government has to meet in order to gain access to these communications. And as I said, the standard is probable cause, but it's different probable causes. It sets forth a provision for internal review within the Department of Justice, and then a secondary review by the court system where a court judge has to issue a warrant. It provides, in some circumstances, for notification to the target so that the person whose information is obtained knows about it and can challenge it after the fact if necessary. And it sets forth penalties for unauthorized interception and disclosure of the information. So we're going to talk about the FISA issue because the wiretaps that the president authorized were clearly not related to the Title III procedure. This was for foreign intelligence information. It could not have met the probable cause standard for the criminal wiretaps, probably, and it's not being justified under that regime anyway. So we look just a little bit closer at FISA. the FISA law, as I said, Foreign Intelligence Surveillance Act, says, okay, here you are, you've got this person, you think that they're an agent of a foreign power, you want to listen to them, you go get a warrant. You go get a warrant from the FISA court, which is called the FISC, but kind of people shorthand call it secret court. You know, it's funny, I have to say, when you think you have a secret court and then you find out the secret court is the thing that you know about, and there's actually an even more secret court. So, you know, this was our old secret court. It's like, the, you know, secret court 1.0. And now we have people in the Justice Department are like secret court 2.0, even though they're not really a court, but okay. So, as I said, the issue is to get the warrant, the government has to demonstrate probable cause that the monitored person is a foreign power or an agent of a foreign power, and that a significant purpose of the interception is the collection of foreign intelligence information. Okay, this is a bit of a change from prior to the Patriot Act. Previously, before the Patriot Act, that you had to show that the purpose of the interception was to collect foreign intelligence information. Now it has to be a significant purpose, but you can have other motivations as well. So it's sort of a lessening of what you need to show. So as I said, you know, that defines the threat differently for people who are United States citizens and not United States citizens, and there are probably a couple reasons for that. On one hand, it might be that the government has a stronger trust relationship with United States citizens and thinks United States citizens aren't as dangerous to our nation. Another thing, which I think is a major factor, is that the Congress likes to treat American citizens better than it treats non-American citizens or, you know, non-U.S. persons. We're just looking for a better user experience with our government for U.S. citizens, but we don't so much care what other people think about our government, as the whole freedom fries debacle sort of suggests. And so we have this provision that, you know, we're going to protect the civil liberties at the very least of people who are American citizens or, you know, are authorized to be here and that sort of thing. Okay, so there's the process, and the process is really important. And this is one of the things about being a lawyer. It's like, you know, the result is important, but the process is important too. And the reason the process is important is because the process has all these safeguards that make you believe that it's fair and that make sure that, you know, the law isn't mishandled. And one of the pieces of process here is this internal review that the Department of Justice does before they ask for one of these warrants from the court. And the internal review has a really important role, which is that it provides for accountability. It's not just like any old agent or any old United States attorney is going to ask for this thing. It gets signed off on by the Attorney General. So we know that when we're going to be collecting this information, there's somebody we can go to and say, hey, you approved it. You're the accountable person. You know, was this right? Is this working? And the second safeguard is the safeguard of judicial review, which requires you to go get a warrant. Now, the warrant is an important part of the process because it has somebody who's outside of the Justice Department, not hired by the guy who's signing off on it, who's, you know, a trained, brilliant legal mind, hopefully. And this person is taking a look at why the executive branch wants to surveil people and making sure that it's the right reasons, that it's in accordance with the law. This is part of due process. Due process is this principle that you know, the law prescribes a procedure and you're entitled to have the government go through that procedure in order to deprive you of your rights. And one of the kind of hallmarks of due process is the principle of notice and opportunity to be heard. That your rights aren't going to be taken away from you without any kind of safeguards. There's going to be something that, you know, that makes sure that it's legally proper, that it's right. And sometimes you can't have notice and opportunity to be heard, right? Sort of your day in court beforehand. If we're going to be listening in on calls with people who are talking to terrorists, we can't say to them, hey, do you mind, you know, if we listen in on your phone calls? So we have this other process, which is a secret process whereby the Justice Department can go to a judge and say, here's what we think, and the judge is the safeguard. The judge may not be you know, he may not be a partisan the way the party who's being listened to would be a partisan in this fight, but the judge is the neutral arbitrator who looks at the situation and says, okay, I agree, this is right, and it's not just overreaching, there's not mistakes here, there is sufficient evidence, and all of that. So we have the judge to be this safeguard. And we need this safeguard because we know that, well, there's two things. What's our threat model here that we're worried about? Well, we're worried about two things. One is we're worried about intentional wrongdoing. Somebody who wants to listen in for their own purposes, to blackmail because this is their neighbor, they want to see how much their neighbor pays on their taxes, they want to find out, that sort of thing. And the other is because we know that mistakes are made. Innocent, honest mistakes can be made by well-intentioned people. If anything that if history shows anything, it shows that people in power can abuse that power to get at their enemies. From McCarthyism to the Church Commission reports, we see that this is true. But it also shows that there's mistakes. And, we've had a number of mistakes in the past couple of years. And I don't mean to single out the current Department of Justice. There's been mistakes throughout our history. But just in the past couple of years, we've had juries reject the Department of Justice prosecutions of a Florida professor allegedly for supporting terrorism. The jury said, no, we think he was just talking. They rejected a case against a guy who was a webmaster for some websites that the government didn't like, and they said, no, we're not going to convict a web programmer for doing websites. We have Jose Padilla, who the Department of Justice told the courts was an enemy combatant here to explode a dirty bomb on United States soil, and that he should be detained indefinitely without charges or access to a lawyer. The court did that, but then 3 years later, the Justice Department went and got an indictment against him, a criminal indictment, on entirely different factual grounds, with no mention of the dirty bomb plot in that indictment. So which is it? We don't know. The FBI pursued an Oregon lawyer who was a Muslim and had represented people who were connected to terrorist cases for connection to the Madrid train bombing, even though the Spanish authorities had told the United States authorities that they believed that the fingerprint evidence was wrong. And it's only because we have judges who are looking at these things that we know that there are other instances where the Department of Justice has brought terrorism charges against people with insufficient evidence, and the judge reviewed that evidence and said, I'm not going to let this case go any further. I'm not going to uphold these charges. So here we have this system of checks and balances, of separation of powers, and of due process that the statute sets up. There are exceptions to this. With foreign intelligence information, sometimes you don't have time to go get a warrant, and FISA provides an emergency provision where you have 72 hours where you can do the interception, surveil the conversation, collect the information, and you don't need to go get a warrant until 3 days later. And the Attorney General can authorize this. So these wiretaps, what do we know about them? Well, we only know what the Department of Justice and the Attorney General and President Bush have said, plus some stuff from the newspapers and from books that people have written recently about the NSA. But what we know is that they basically were eavesdropping on conversations that they claim were between al-Qaeda operatives and American citizens. And the law is crystal clear that in order to listen to American citizens' phone calls for foreign intelligence purposes, you got to go get a warrant, either beforehand or within 3 days. So we know that the Foreign Intelligence Surveillance Act was violated. It's clearly illegal by the statute. So why do we care if what they say is, well, we're just listening in to why, to conversations with terrorists, with known terrorists? As President Bush said, if al-Qaeda is calling you, we want to know why. Well, I don't necessarily have any objection to that. I think if al-Qaeda is calling you, maybe we do want to know why. I just want to know that there's some evidence that it is al-Qaeda calling you and that the process was entered into and that we know what really happened. The problem here is we have no idea. We don't know. Nobody knows whether that claim is true. And no one can challenge it. We don't know who was intercepted. We have no idea. And we just have to basically trust. Our system isn't based on just trusting. Our system is based on checks and balances, on separation of powers, on due process, on notice and opportunity to be heard, on a burden of proof that you have to come forward with evidence before you deprive somebody of their rights. So there were two theories to sort of finish up this kind of discussion of the NSA wiretaps. There are two theories that the administration has put forward as being reasons to justify this interception. And one theory is that when Congress authorized the president to use military force against al-Qaeda following September 11th, that authorization was also an authorization to wiretap. The second theory is that the Constitution gives the president inherent authority to do whatever he deems necessary when fighting terrorism or dealing with foreign threats. So I'm just going to take these briefly. So that we have this authorization to use military force. If the statute says, FISA says, it is a crime to intercept American citizens' phone calls without a warrant unless some other statute authorizes it. And so the administration is claiming that this authorization is a statute. And I'm not going to get into whether I think it's a statute or not a statute, or all the canons of statutory interpretation by which we would analyze that thing. The point is that, the question is, does it authorize surveillance? It doesn't say anything about surveillance. It doesn't have anything in the statute about it. Basically, the question would be, is surveillance of American citizens so tied to what the authorization allows that that Congress actually gave its permission when it passed the authorization to also disregard this very sort of robust and complicated, or not complicated, but thorough, complete scheme by which you get authorization to do wiretaps. And I think the answer to that's pretty clear. We can tell because Congress is so pissed off about these unauthorized, warrantless wiretaps, and that's Republicans and Democrats alike. But during questions, if people have issues or want to discuss that, I'm happy to discuss that further. I think one of the best arguments, though, about that shows that Congress didn't really think that when they were authorizing military force, they were also authorizing disregard of our privacy laws, was that following September 11th, Congress spent time passing the Patriot Act. And the Patriot Act has a lot of provisions in it which modify FISA. And if Congress thought that it was sort of throwing FISA out the window with this authorization to use force, it wouldn't have needed to spend so much time and modifying FISA and passing the Patriot Act so expeditiously. Okay, so then the second issue is this constitutional theory that the president has the inherent authority to disobey the law. And this is really interesting, I think, as you guys listen to the Alito hearings that are going on now, and thinking about, like, what does it mean to be, no man is above the law, or what does the rule of law mean? Basically what what the administration theory is, and this is a theory that they've put forward in many other instances, whether it's dealing with torture or detention of people in Guantanamo, or rendition, transporting people to other countries for interrogation, or disregarding the Geneva Convention. They have justified this under a very expansive view of what the president's power is during wartime. We don't have a sort of official declaration of war from Congress, but we know we're at war in Iraq, and we have this sort of war on terror, which is like the war on drugs or the war on cancer, could last for quite a long time. But they have made this argument that the powers of the president are without limit, unlimited, when it comes to the field of dealing with foreign threats. And despite the best efforts of the administration lawyers, there's actually 0 cases that support this proposition. In fact, there's a case that says very clearly, even during wartime, the president has to follow the law and is subject to the rules, that Congress sets forth. And has to obey the statutes. So we talk about, is the president above the law? Does he have to obey the law? And, in the thing with the Alito hearings is that Judge Alito is saying, I believe in the rule of law. I believe no man is above the law. And that's it's a little bit of a, it's lawyer talk, and so I'll just sort of decipher it to you. It should give people who think that the wiretaps were illegal and that the president should follow the law absolutely no confidence whatsoever in this particular candidate for the Supreme Court. Because the law isn't just, when he's talking about the rule of law, he's not just talking about the statutes, he's also talking about the Constitution. So if you have statutes that say, here's what you can't do, but you have a provision in the Constitution that says, but the president's allowed to disregard it, and the president disregards it, he's still following the rule of law because the Constitution says he's allowed to disregard it. So when he says, no man's above the law, I believe in the rule of law, it doesn't mean he believes that the president is bound to follow the laws that Congress passes, even though that's what all the cases say, and there's no cases that say otherwise. Okay, so just sort of a little legal obfuscation that's common in the hearings. Okay, so we have here, with this kind of breakdown of the legal process, is a situation where we've lost track not only of due process and separation of powers and checks and balances, but we've lost track of the kind of oversight and therefore the legitimacy that wiretapping American citizens needs to have in a democracy, where for people to be behind it and to understand that it was necessary and that it was right and that it was done under the right circumstances. Yes, maybe the Attorney General approved it, but it couldn't go through the normal channels. In fact, when they asked the second in command in the Attorney General's office to approve it, he said, no, I won't do it, and White House officials had to go and visit Ashcroft on his hospital bed as he was getting his gallbladder surgery in order to have him sign off on it. That's not the normal procedure. Did they talk about it with Congress? Well, they cherry-picked some members of Congress and one of the judges on the secret court and told those people, a handful of people, but said, but you're not allowed to discuss it. You can't discuss it with anybody, or you're bound to keep it secret. That's not the usual oversight procedure. That's not Congress doing it's a few members of Congress being informed, but it's not Congress making sure that the policy is working, not Congress being aware of exactly what or who. It's not Congress getting the reports about how many or under what circumstances or what the results are, or did we get anything good out of these intercepts or anything. So the problem here isn't just that we didn't violate. It is not just that we violated the law, that the Bush administration violated the law. The Bush administration isn't the first to intercept people without a warrant illegally, and it won't be the last administration to do so either. But it is one of the first to say that the rules don't even apply to it. And we know that the rules are important. The rules are not only here to sort of uphold and make as checks and balances, but the rule of law is sort of the basis of the democracy, that we're not ruled by a king, but we're a system of laws, not a system of individuals or of men. So this is a little bit similar to these sort of principles that fit together to balance when we need to do investigations and when we need to protect civil liberties, are similar to these principles for secure design. So as I said, the legal principles we've talked about are due process, separation of powers, checks and balances, notice and opportunity to be heard, and the rule of law. And we can sort of compare these to the design principles, the principle of least privilege, which is basically, it is described in the book as a subject should be given only those privileges necessary to complete its task. Function, not identity, controls, and this is similar to the principle of enumerated powers. The Constitution says what the powers of the president are, what the powers of Congress are, what the powers of the court are, what's left to the states and to the people, and that we have a rule of law. It doesn't matter the identity of the person. We have a process that's in place, and we follow the process. There are standards. It's not pure discretion. The fail-safe principle. Default is that you deny access, or default is that it fails safe. And so do we have fail-safes? In FISA, we have fail-safes. There's a 72-hour sort of window where you can go and do the interception without having to get a warrant. That's one kind of fail-safe. Otherwise, we require proof. We require the proof. We need some sort of probable cause. And I thought about this sort of fail-safe long and hard, because I was thinking, well, what does safe mean? Does fail-safe mean that we fails and civil liberties are protected, privacy is protected, or does fail-safe mean it fails and we get the terrorists? Like, which is it going to be? And I think that the fail-safe principle applies in the law in a more kind of a more fundamental way, because it's not so much because we're always going to be trying to balance these two questions, and we're going to use these techniques to balance it. Ooh, there's a bird in here. Some sort of spying, homing device. It's over in the back. But I think the bigger issue is that you want it to fail towards the rule of law. It needs to fail towards legitimacy. That's the real issue. So, when it fails, we want it to be, there's checks, there's balances, there's consequences, there's oversight. People know what happened. Okay, so economy of mechanism is basically a keep it simple or make it simple. This is one of the problems with coming up with a kind of little gimmick for your talk, which is not all of the little pieces fit. I didn't want to leave it out because Professor Bishop put it in, but this one doesn't really work. When you look at FISA, or you look at our wiretap laws, or you just look at any kind of compendium of United States code, and it's this thick and it's complicated, and it's just impossible to make it safe, and I think or to make it simple. And in some ways, I think that's a hallmark of how delicately legislatures try to do this balancing between privacy and between balancing privacy and also having the access to information that law enforcement needs. Complete mediation. You check the access. You usually check first before the access is allowed to make sure that there's authentication, and you make sure that the permissions haven't changed later on so that the accesses, as they continue throughout time, are always authorized. Well, we have this in the statute. We have a warrant. You've got to get it first, generally, and after that, there's reporting requirements. You report to the judge and you report to Congress, and we know what's going on. Same exact thing. Open design. Security shouldn't depend upon the secrecy of the design or the implementation. True also with a democracy. Sometimes we need to have secrecy. There's some things that, would impact investigations if the public knew about it. But as a general rule, for the purpose of accountability and for legitimacy, our statutes try to minimize, our law tries to minimize the amount of stuff that you keep secret from the American people in a democracy. It's important. Separation of privilege. This one's sort of obvious. It's the same as separation of powers. Least common mechanism is this principle sort of that mechanisms should not be shared. And this, I think, is really evident in our privacy statutes. If you look at all of our kind of privacy, the way that we set up our privacy laws, to the extent that the United States has privacy laws, there's a limit on how information can be used and who can access it and what the authorizations are good for. So if you get information, what are you going to do with it, and who's getting access to it later. So just as like a great example of this, for New Year's, I think was it 2003, or I can't remember which year, they had some tip that there was going to be a terrorist attack in Las Vegas. So what law enforcement did was they took a national security letter, a sort of process that doesn't really require a probable cause showing, and went to the hotels in Las Vegas and said, okay, tell us everybody who's staying in your hotel. And the hotels complied and gave the government all this information about everybody who was in Las Vegas for New Year's. No terrorist threat materialized, nothing happened. Where's that information now? Who has access to that information? Will it be accessible next year, 10 years, 20 years, and for what purpose? Will we be able to get it for civil lawsuits, for any kind of criminal investigation, will we be able to get it with, just a request, or will we have to ask a judge to be able to see it? What happens to this information after it's collected? And the idea is that, even if it's necessary to collect the information at a certain point in time, at the time with that necessary, we need to have it, we can get rid of it. We don't need to have it sitting around forever. And finally, psychological acceptability, which I sort of boil down to the idea that there's human factors, important human factors, in setting up a secure design. The idea is, well, we don't want the security mechanism to make the system so much more difficult to use that people won't use the security, or that it really interferes with the effectiveness of the machine. And I sort of translate that into, in the legal side, is the idea that we want to have the burden be commensurate with the privacy impact or the civil liberties deprivation that we are authorizing. And at the same time also realizing that there are human factors present here. People are corrupt, people lie, people make mistakes, people are out to kill us. All these things are true. We need to take this into account when we're designing our legal system. Okay. All right. A lot of people have been really interested, and I think probably people in this room are really interested in what exactly was being intercepted and how. We don't have a lot of information on that. The New York Times in its story said, we're not going to reveal the technology or details about the surveillance because we do think that that would be giving people information that's not currently in the public domain about how surveillance is conducted. There's been recent books about the NSA which discuss some of the, which discuss technology a little bit. There's been statements by United States senators who've been briefed on surveillance issues and the intelligence program who say, it seems to me like we've got a major change in technology here, perhaps more so than a change in policy, which is what we're grappling with. So what exactly is the technology? How exactly was this information obtained? And what does it mean for the future? Well, I think that the answer to this, we don't really know, but I think the answer to this is somehow in what I think has been the most difficult question for me, which is why did the administration do this? It's not explainable, I think, by hubris, which is a favorite explanation that, a favorite explanation among liberals like myself. I don't think it's completely explainable by the loss of faith in the FBI that I think that maybe the American people and people in the government had following the intelligence failures that were prior to September 11th. And I don't think it's because FISA really is too burdensome. And we can talk about that. I want to try to leave some time for questions. But, the standard is probable cause that somebody's an agent of a foreign power. And after the Patriot Act, you don't even have to necessarily prove they're an agent of the foreign power. We have this lone wolf exception, and we've sort of lowered the probable cause standard. And the FISA court approves almost every warrant application that it receives. So I think that the question about why is kind of tied into this question of what the new technology is. And I wonder whether it's true that FISA would not necessarily have authorized this type of surveillance because the type of surveillance that we're able to conduct now is categorically different from the type of surveillance that was envisioned in 1978 when FISA was implemented. I look at programs like the proposed Total Information Awareness, a kind of database of databases of information about Americans, or the Flight Surveillance Program, CAPS and CAPS-2, or CALEA, the Computer Assistance to Law Enforcement Act, which says that telephone companies and now internet providers have to build wiretapping capabilities into their systems. And I think maybe we're about something that's just technologically very different. We're able to do something that's just technologically totally different from me listening to your conversation. CALEA is sort of a kind of window into this, because there's no way that, if you look at what the FBI has requested under CALEA, there's no way that they have enough people to listen to all those phone calls or enough judge to authorize all those warrants given the surveillance capabilities that they're asking for. So when you have this vast amount of data and you don't have enough people to go through it by hand, there's some sort of automation or some kind of computerization of the surveillance going on there. And so the question is, what is this and is it different? So I just want to read a little part of an op-ed by a constitutional law professor at Harvard, and his sort of thinking about what the technology might be and whether it's good to use it. His conclusion is it's good to use it. We need to use this technology in the fight against terrorism. So this is Charles Fried. Programmed into the computerized scan are likely to be automatic prompts that are triggered by messages containing certain keywords, go to certain addresses, occur in certain patterns, or after specific events. Supposedly, those messages that trigger these prompts are targeted for further scrutiny. In the context of the post-9/11 threat, which includes sleeper cells and sleeper operatives in the United States, no other form of surveillance is likely to be feasible and effective. But this kind of surveillance may not fit into the forms for court orders because their function is to identify targets, not to conduct surveillance of targets already identified. Even retroactive authorization may be too cumbersome, and in any event would not reach the initial broad scan that narrows the universe for further scrutiny. Moreover, it is likely that at the first broadest stages of the scan, no human being is involved, only computers. Finally, it is also possible that the disclosure of any details about the search and scan strategies and the algorithms used to sift through them would immediately allow countermeasures by our enemies to evade or detect them. Okay, so let's say this sort of proposed technology that Professor Fried is talking about is true. It may not be true now, but it's going to be true soon, right? It seems like what we're sort of going towards. And then the question is, when we have these capabilities, what are we going to do with them? Are we going to implement them? And if we implement them, how? And this is where I think hackers play a very special role. Hackers are people who understand the technology, they're willing to ask the unorthodox, difficult questions, and they understand how to design secure systems, not only technologically, but also legally, seeing this technology not only as a system unto itself, but as part of a broader system, which includes statutes, constitutions, and our principles of democracy, our values that we want to live up to. There's a lot of questions I have about technology like this. Are there too many false positives for something like this to work? Given the number of communications and the percentage of hits and what we're looking for, would it even be able to target or find real hits given that people talk in code, and exactly are we going to look for? I remember when the journalist Daniel Pearl was kidnapped, one of the things that the paper reported was that the kidnappers would repeatedly misspell his name or put a space in his name or do different things to evade any kind of detection of their communications about him, sort of like when you get the Viagra spam, it has the @ sign in it. I don't understand why if I know that, my computer can't learn it, but okay. So, is it, given people have been talking in code and hiding things from other people for centuries, are we going to really be able to develop an algorithm that will actually get, these things? Have we done any research? Is there any research out there? And I haven't found any on whether mass surveillance is effective, or is it any more effective than targeted surveillance is? Even if it's not that effective, is it worth it? Because it kind of narrows down the field, and then you can use other sorts of surveillance or investigation techniques in order to find the people who are out to get us. We have to consider, we have to balance these things, consider what level of information, what level of effectiveness justifies not only the expense, but also the expense to our civil liberties and the deprivation of liberty. But it's not a zero-sum game. It's not binary. This is the place where in speech normally people will say, well, we'll do anything to catch the terrorists. We have zero tolerance. Any measure is appropriate if it helps catch terrorists. But this is a make-believe world where we can do anything and every measure is available to us and they're going to catch terrorists, just as much as it's a make-believe world to believe that there aren't terrorists out there who are trying to kill us. We have to look at this in the way that it really is going to work, which is we don't have unlimited resources and we don't have an unlimited, we have the human factors as well. We don't have assurance that everybody will do everything right and that it will only be used for the purposes that we might want to be. So you are the people who understand technology, and technology for mass surveillance probably will be deployed. I'm not, particularly optimistic that it won't. I think that there are people in this room who will build that technology. And I think there are people in this room who will vote for the politicians who allocate the money to build that technology. When that happens, I think the people in this room are particularly adept to see the technology as part of the larger system, not just keeping the surveillance system safe from hackers, but keeping the entire system safe from wrongdoers and from people who make mistakes, from innocent mistakes by people who are trying to protect us from terrorism but are off. Secure design means not only that the technology is secure, but it means designing the technology to interoperate with our system of checks and balances, our legal principles, and our democratic values. It has to be implemented according to these principles and to the rule of law, and to some extent, even if we implement technologies of mass surveillance, we can code into the way it's designed these principles that are the things that help keep us free. People in this room are the ones who have the tools to build this future society, a society that's secure, by which I mean safe and free, secure from terrorists and secure from government intrusions, secure from fascism. And as I think the comparison between the secure design principles and the legal principles shows, securely designing policy isn't necessarily all that different from securely designing technology. So you know a lot more about democracy and policy and privacy statutes perhaps than you thought. And my entreaty to you is to use that knowledge when working on the projects that you work on, when voting, when talking to your congressman, when thinking about these issues, when being an American citizen as well as a technologist. So that's my comments, and thank you. So I will take questions. Do I have question time? I can take questions? Okay, questions. Angry comments. Yes, this gentleman in the front.
In extending the Cali law to include internet, it seems to me that one of the things Congress, or not Congress, but FCC has done is start development efforts in a number of companies to look at how you can, in fact, meet all of the Cali criteria within the context of an internet, for example. And so that raises, in my mind, a number of questions.
Okay, so let me just repeat where you've gone so far, just so people in the back are not falling asleep. They look alert, but let me just tell you. So we're talking about CALIA for the internet and what what questions that raises.
Right. CALIA basically says that, or the extension of CALIA basically says that the same things that were required of the original wiretap laws, that you be able to identify who is making the phone call, when did they make it, where, who are they connecting to, how long did they talk, those kinds of things.
Right.
Could be somehow provided when
I know, but can you
get
get to the question part? Because I'm not going to repeat that for them then.
Has to do with, suppose several companies, in fact, develop this capability. Is there a difference between the government buying that information, for example, and private companies buying it, or foreign governments buying it?
Okay, so the question is about once we have the capability to collect so much information, either through wiretaps or CALIA, and it is a vastly greater amount of information than it used to be because so much of our communications are now electronic or over the web, is there some difference between the provisions for government's lawful access to the information, whether it be FISA or the wiretap law, and private companies being able to get that information, or even foreign governments to be able to purchase it? And this is a huge hole in our privacy laws right now because we have these rules that say government can only get information under these circumstances, yet at the same time we have private companies collecting all this information for their own marketing purposes and everything, and then they sell them to your choice point or whatever data broker it is. And the proposal from our government is, well, we're not going to get warrants, we don't need warrants, we're going to buy access to these commercial databases, and that's not governed by statute. So legally, is there a difference? Probably. Privacy-wise, is there a difference? Not at all. It's a huge privacy violation, and this is something that I think is like a hole in our statutes that's going to need to be addressed. I think I suggested in my talk that perhaps the ability to do mass surveillance is a hole in our statutes that either needs to be addressed or will be addressed at some point. I think that the profusion of commercial databases that collect our personal information is another one. It's not just an issue with government, with privacy from government intrusion. It's also with identity theft and marketing and, privacy from private parties or from commercial entities, which is not something that the United States has guarded against much, but something that the Europeans worry about a lot more. So, yeah. Yes. Yes.
For any automated surveillance, that implies you're probably not using STAG, and it implies that you're probably not using crypto, and they already know that Al-Qaeda is, quite versed at doing both. So that sounds like, that they're really targeting people that not well associated with Al-Qaeda.
So the question is, given that we know that terrorists know how to use steganography and cryptography, and the mass surveillance, is it going to, if it's looking for keywords or something like that, it's not going to be picking up any of the thing from these communications. It's sort of, his suggestion is that it belies the true motivation of the surveillance, which is that, it's not to capture terrorists, but to capture people who aren't using encryption, and we know the terrorists are using encryption. And, the only thing I can say about that is that it may be true, but, I think that the government view of that would be we want to have whatever tools are, in fact, available to us, whether people are using encryption as code or, sort of language as code. I just know from my experience as a criminal defense attorney that everybody always tries to cover their tracks, and a lot of people still get caught. So I know that sometimes, the surveillance will work even if people slip up, basically. There's 1,000 ways to get caught, and if you can think of 100 of them, you're a genius. So I appreciate your comment because I think it goes to the effectiveness of the tool. But I think that, what the government would say is, well, we still need to do what we can, basically. I see a comment over there.
The New York Times ran several full-page ads recently regarding these confrontations with President Bush about the surveillance that he's doing in ways in which they think he's broken the law. I think the EMF, in fact, responds to these ads. What is your impression of this kind of effort? Is anything going to come of any way that people can oppose what the government's doing?
So the question is, we have ads and sort of telling people about the view that this was illegal, and is this going to work, and what can people do? And I think absolutely it works, because remember, this is a democracy. We are the people who matter here, and when people, if you're alone in believing something, you might not have much force. But as you join together and you understand what's going on and you think about it, you're given opportunities to either legitimize policy decisions that are made, or to vote later on, or to give money to your congresspeople, or all the ways in which people participate in a democracy. In aggregate, it absolutely matters. If only because this opens up this debate and this issue about rule of law and about separation of powers, and really starkly brings to the forefront exactly what the Bush administration's theory of presidential power is. I think it's been, the information that American citizens have now about what's really going on with our government is so much greater, and I think that it definitely makes a difference. It will not be like that, but it will roll, as people realize what's going on. In the way back in the tantrum. Yeah, yeah. Evil versus stupid is his question.
Does the difficulty in communicating technical reality that underlies all this stuff, jurors or judges or congresspeople or something like that, to what extent does that impact a lot of these decisions? When I pulled up my congressman before to argue against various laws to look at security research and stuff, they hadn't a clue. There was no way I could begin to discuss this stuff with them. I would think if you're in front of a jury, to start talking about things like cyber attribution or repudiation or even issues of crypto or something like that, you have a prayer on how to present that to them. So
Yeah.
what's the impact on that?
Did you guys up here in the front hear that? Do I need to repeat it? Okay, so basically his question is, what's the role of ignorance about technology and the legal system, and how much is that a reason why people might want to bypass it or feel like the legal system's not going to work because judges and juries don't understand the technology? And I have a personal story about this, which is one of my favorites, where I was doing this hacker case down in San Diego, and they had logs which purportedly showed that my client had accessed this web server, and I was cross-examining the police officer about the authenticity of the logs, which were edited. They had basically pulled out everything that was my client and erased all the rest of it. And I was saying, these aren't the real logs. You basically cut and pasted this into a separate document, didn't you? And the judge is like, wait, you mean with a scissor? And I realized that everything I was saying about the log, he didn't understand the logs, what the log was, and basically was sort of out of it. So there is, and there has been a real, sort of rift between what people, between the knowledge of the judges and juries and all of that. But I think that, in terms of passing good laws to deal with stuff like technologies of mass surveillance, we have people who are specialists in this kind of stuff, either on the secret court or in Congress, and, judges are getting more educated. The FBI's forensic work has improved multifold since I've been in this business. They're much better now at it than they were before. They train prosecutors and defense attorneys in how to explain this stuff to juries. And my personal bias about this is that I think you're absolutely right. There's a learning curve. My personal bias is that the learning curve favors the prosecution, because these are the people who come to the court without any kind of personal agenda or bias. They're only there because they're trying to get the bad guys. And I think that the juries and the judges tend to, when confused, believe what the prosecution says as opposed to what the defense says, because of course we have a ill motive because we're mercenaries for hire, just trying to get our client off on any kind of technicality. So, given that that's the case, I think it tends to favor enforcement as opposed to lack of enforcement. But I do think that gap is I do think that over time that gap is narrowing. I think it's narrowed quite a bit since I got into this business. The gentleman over there in the gray shirt. Yes, you.
Congress frequently points fingers at CFOs and CEOs and passes a lot of regulation to put other people in jail. But at what point does Congress take responsibility for not declaring war formally in 50-some odd years, not actually paying attention to what they pass, and haphazardly granting the executive branch power? At what point can we go, if the courts say that this is okay based on the power granted to the president, or supposedly granted to the president after 9/11, at what point can we go say that Congress as a body needs to be not convicted, but whatever?
Yeah, I mean, how are we going to hold these people accountable, right? You know, and when are they going to take responsibility for the decisions that they make instead of saying, you know, in particular, I think if you believe that the authorization to use military force was also an authorization to eavesdrop, and now you've got Republicans and Democrats alike saying, ooh, people don't like it, I'm not going to, you know, I'm going to say I didn't really mean to vote for that. It's like, you know, so that would be one, you know, sort of the other side view, I think, that they're of Congress not taking responsibility. So what are you going to do? You're going to vote them out and get other people in? You know, I'm a big optimist about American democracy. I love the United States, and I think democracy is, you know, the best form of government out there, but I realize it's deeply flawed and it's imperfect and it's incremental. So, you know, who are we going to have as other choices? Will the other people be more responsible? You know, I don't know, but you start by picking the people who are responsible and who do say what they mean and who aren't out there just feeding you a lot of bullshit, and you support those people. My favorite senator is and has been for the past couple of years is Russ Feingold, who was the only person who raised questions about the Patriot Act back in, you know, back right after September 11th when it was passed, and continues to lead the fight in explaining why it is that we need to have safeguards and due process and that sort of thing. And I send him money whenever, you know, whenever he's up running for office again. And I hope that that's just a little way in which I can say, you know, this is a guy who has the principles that I agree with, and so I support him. But I agree with you, there's a lot to be frustrated with in terms of our Congress people. I'll take this question over here. He is asking me about the Transparent Society. I have not read it.
His response to Trump's issues of surveillance, that more surveillance, that the total surveillance that everyone has access to, that it's inevitable, and the best way to test one of those things.
Yeah, he's asking about this idea that, like, the surveillance problem is fixed by more surveillance, and that, you know, if everything was available to everybody at all times, then it would be, I guess, a sort of a needle in a haystack sort of thing, and, you know, we wouldn't be so worried. And total accountability and that sort of thing. And, you know, I guess my feeling about that is, I have a lot of feelings about that, but I think the most radical thing I could say about that is I think that our society is built on non-accountability. I think that if we lived in a world where people got caught every time they broke the law, it would be a pretty scary world. And you think about just in the past couple of days, how many of you have done something that breaks the law, whether it's, you know, I'm serious, you know, I have this argument with it. You know, people like to think, so I'm giving you this is my most radical view, you know, people like to think there's the criminal element and it's them. It's like, well, have you ever taken a pill when your prescription, you didn't have a prescription for it? That's a crime. Did you smoke marijuana when you were in college? It's a crime. Did you ever drive drunk? That's a crime. If you ever hit your boyfriend or girlfriend, that's a crime. You know, and I think that if we had a world where people got caught every time they did something wrong, it would look a lot different. One of the reasons why we tolerate a lot of these kind of driving without your license on you, crime. You know, one of the reasons we tolerate these kind of low-level criminal offenses is because we don't get caught every time. You know, if we got caught every time, I think it'd be a lot scarier place. So I don't believe in total accountability. I think total accountability is based on a fiction about what it means to be a criminal versus a good guy. So, Bob Stratton. Hi.
I saw a stirring op-ed last year by T.J. Rogers, the CEO of Cypress Semiconductor, basically saying if the choice is living in a police state, wouldn't be his choice. Probably a bad business decision. And I was sort of surprised because this guy he's arguably one of the captains of industry in the United States. I was wondering if you've seen other technology company principals come out and say anything to that effect or organize with regard to this issue one way or the other since you're out in the Bay Area.
Yeah, you know, not so much actually. He's asking me about whether, you know, people who are like technology, you know, leaders of technology companies have taken a stand on this or other issues. You have the sort of famous, you don't have no privacy, get over it, right? So there's that kind of view. And then, you know, has anybody said anything about this? And I think, you know, unfortunately, as the kind of technology companies, I use this word advisedly, mature, they become more political and less of evangelists than they might have been. So we see companies that perhaps we might have thought of as being run by people who were, you know, kind of had some sort of alternative principles. We see them, you know, basically doing business in China or other countries, and they say, okay, well, in order to do business in China, we have to turn over information about this journalist that China wants to put in jail. We have to enable the government to shut down people's blogs if the government doesn't like what the blogs say. And so I think that companies, basically their hallmark and their duty to their shareholders is to make profit. And so I think that as the companies have become profit makers and had shareholders, we see a lot less of individuals going out on a limb in that way, sort of one way or the other, and more thinking about, I think, how to capitalize upon what the trend might be. So, yes. So the question is about paperless voting, which I think is really bad. And what's the connection to Supreme Court nominees? Oh, yeah, the accountability issue. Yeah, I mean, I think the paperless voting is probably one of the scariest things out there. I think anybody who works with computers knows that when it spits out a number, it doesn't necessarily mean that the number is true. It makes me think of when I took my car in. I have a Civic Hybrid, of course, and I took it into you guys get it. I took it into the dealer, and the light was on the dashboard. I said, the light's on, and they looked at it, and they called me later in the day. They're like, okay, you can come get it. And I said, well, it was pretty new. So I was like, what's wrong with it? And they said, oh, nothing. We just had to download the patch from Honda. And I realized, there's nothing that the car tells me is true. It's totally intermediated by software, and the software could be anything. And so, you just can't trust the voting machines, and it does have to do with accountability. But I think that the people who have been in the forefront of the paperless voting and issue are really driving that home to people and have made a big difference there. So I think we're in as I said, I'm very optimistic about democracy, but I think we have ebbs and flows, and I think we're in an ebb now, but I think we're going to be in a flow later, and we're going to be okay. So yes, next to the light.
So you contrasted targeted surveillance versus mass surveillance, but I wonder if you have anything to say to the following other than that there's probably no case law now yet, which is I wonder in cases like where they by whatever means, not saying, say, okay, we're able to figure out that there's some bad guys in this town of 10,000 people, and we feel that we do broad surveillance on all 10,000 people, we'll narrow it down.
Okay, so yeah, I mean, I think this is the question. It's like, how many people can we surveil to sort of narrow it down? And what we've seen is things like these national security letters used to get information about everybody who's staying in Las Vegas. Or we see something like the CAP system set up in order to kind of scan through passenger records and find out who seems suspicious and put them on a no-fly list. So these are things that the government is doing right now, trying to implement these kind of data mining technologies in order to try to narrow down, what the threat is. And there haven't been a lot of legal challenges necessarily to them, mostly because of issues about when you give your information up voluntarily to a third party, like when I give it to the hotel, or if I give my information to Amazon, or if I give my information to a bookstore or something like that, library. There's different rules about sort of the Fourth Amendment doesn't apply because I don't hold on to the information. I've given it away, and since once I've given it away, it's kind of considered public, and that person is free to give it away again themselves. So we have this real change now that almost all our information is in the hands of third parties as opposed to held personally with ourselves. We have this real change in the amount of information about us that's protected by the Fourth Amendment versus information that is out there and is unprotected. So it's a real, and again, something where technology has totally altered the privacy balance, and we haven't seen either statutes or constitutional law adjust yet to kind of put it back into perspective or to figure out if this is the way that we want things to be or that sort of thing. So, mass surveillance of some scale is definitely going on now, whether it's in this warrantless wiretap scheme or with national security letters or other things like that. But as time goes by, we're going to see more challenges, and we'll see people questioning whether this is exactly whether this is the kind of society that we want to live in. So that's all the time that I have for questions. I will be here until tomorrow. I'm happy to talk about these issues with you, and thank you very much for listening and for your questions.